Hello everyone, welcome to my channel Dolly LB. Today I am going to discuss one of the landmark precedent pronounced by the Honorable Supreme Court of India in the case of X vs Y, Criminal Appeal number 7210 of 2024. Today we are going to dive into the significant Supreme Court ruling from July 8, 2024. This particular decision addresses a crucial issue in the matrimonial laws, the ground for the divorce on the basis of the desertion, as per the Hindu Marriage Act 1955. The Honorable Supreme Court of India has said that a divorce petition can be presented on the ground of desertion if there has been no resumption of conjugal life between the parties to the marriage for a period of 1 year, and more after passing such a decree. A bench of Honorable Justices Abhay S. Oka and Ujjal Bhuyan allowed a petition filed by a man against the High Court's order which set aside a decree of divorce granted on the ground of desertion. The court also noted that this is a case of complete breakdown of marriage between the parties for the last 16 years and more. It was also found that the desertion of the appellant, at least from 2008 till the date of the filing of the divorce petition in the year 2013, which continued without any reasonable causes. The Honorable Bench said that therefore a decree of divorce on the ground of desertion under Section 13 Clause 1 Subclause IB of the Hindu Marriage Act ought to have been passed in favor of the husband. Thus, in our view, the Honorable High Court had to confirm the decree of divorce on the ground of desertion. The court also noted that the marriage between the parties was solemnized on dated 25th of March 1999. Two children were also born from the lawful wedlock. Both of the children are adult. The matrimonial dispute led to the multiple litigation between the parties, and the discord started in the year 2006, which led to the appellant filing a petition under Section 9 of the Hindu Marriage Act 1955 for the restitution of the conjugal right in order to demand the homecoming of his wife. The man had also filed a plea for restitution of conjugal rights on December 17, 2008. By the judgment and decree of the Honorable Court of Additional Civil Judge Senior Division, Barnala, on dated 15th of May 2013, passed a decree of restitution of conjugal rights under which the respondent wife was directed to join the husband's company within a period of 3 months. As the respondent wife did not abide by the decree for the restitution of the conjugal rights on dated 23rd of August 2013, the appellant had filed a petition under Section 13 of the Hindu Marriage Act 1955 before the family court at Barnala, seeking a decree of divorce on the grounds of cruelty and desertion. Thereafter, the wife had preferred an appeal before the High Court of Punjab and Haryana, which was dismissed by the judgment on dated February 19, 2015, and the decree of restitution of conjugal rights was confirmed on dated 1st of August 2016. The judge of the family court at Barnala allowed a divorce petition filed by the appellant husband and dissolved the marriage. The respondent wife challenged the divorce decree by preferring an appeal before the Punjab and Haryana High Court, which by its impugned judgment dated 4th of October 2019 set aside the divorce decree. The High Court has held that the ground of desertion was not made out as the appellant had continuously neglected his duty as a husband, and considering his conduct, the respondent had no choice but to leave him and to stay at her parental home. But the apex court bench, however, overturned the decision and said that, in our view, it is not possible to sustain the judgment of the High Court on the issuance and issue of the desertion, because the court also found that nothing was brought on record by the respondent wife to show that after 19th of February 2015, when the decree of restitution of conjugal rights was passed and confirmed by the High Court, any effort was made by her to resume the cohabitation with the husband. Hence, we must note that between August 1st, 2016, when a decree of divorce was passed, and October 4th, 2019, when the decree was set aside, no efforts were being made by the respondent wife to resume her conjugal life with the husband. She had not made any such cases. Moreover, there is no material on the record to show that after the decree of the restitution of the conjugal rights was passed, the respondent showed even an inclination to resume cohabitation with the appellant, The bench said, referring to Section 13 Clause 1A, Subclause 2 of the Hindu Marriage Act, the bench pointed out that it is provided that a divorce petition can be presented on a ground there has been no restitution of the conjugal rights between the parties to the marriage for a period of 1 year and more after passing the decree for the restitution of the conjugal rights. The court also said that the appellant has offered to pay the respondent, a wife, a lump sum alimony of 30 lakh rupees, which is a reasonable and can be accepted. Though we are passing a decree of divorce on the ground of desertion, we will have to clarify that the decree shall come into operation after a sum of 30 lakh rupees is being paid by the husband to the respondent wife, the bench said. So this is a primary observation which has been observed by the Honorable Supreme Court of India in this particular judgment, where the decree of divorce can be granted on the basis of the desertion which was committed by the wife. The link of this particular judgment will be present in the description item. Read it, analyze it, use it in the day-to-day proceeding of your civil court practices so that you can guide your client as well. Thank you so much.